Um, Okay, let's start that again. I am attorney Nydia Menendez, and I want to thank you for joining the webinar. You could be doing a lot of other things, way more fun than this, but I guarantee you that few things in life will have as much impact on your life and on your legacy as estate planning does. Now, you're going to be learning tons tonight. So I guarantee that. And because I know that it is not the most fun topic in the world, I have sprinkled the presentation with a bit of humor and a lot of reality. And what I mean by that is that I'm going to be sharing numbers with you tonight. And those numbers are current numbers, actual for South Florida, as much as we could find them. And they are as recent as we could find them. And I will let you know if they are averages or what have you as we go along the presentation. Now, we also want this experience to be interactive for you. So we will be launching polls so that you can tell us what you're thinking about. All the polls are going to be anonymous, meaning that we will not know who answered what. So you should feel free to express your thoughts and concerns when we do the polls. I also want to let you know that throughout the presentation, you can use the question or chat box to ask questions, and time permitting, we will answer as many questions as we can at the end of the presentation. And we're also going to be following up with you to see if you have any questions for us. But before we get started, I wanted to introduce my co-host. Tonight, my co-host will be Maciel Leiva. And she is the one who's going to be launching the polls and checking the questions in the chat box. So Maciel, can you tell our participants a little bit more about you?
Yes, Nadia. Good evening, everyone. I am Maciel Leiva. I am the Client Services Coordinator here at Menendez Law Firm. I also want to welcome you all to our Wills, Trust, and Estate Planning webinar tonight. As Nadia said, I will be answering your questions in the chat box, so feel free to drop any comments or questions there, and I look forward to speaking with you later today. Nadia, back to you.
Okay, and so what I am going to do is I am going to share my screen right now, and let me go ahead and get that in slide mode. And like we just said, we're going to be launching polls. So let's go ahead and get started with the first poll. Maciel.
Yes, so poll question number 1 is asking, what would you like to learn today? We have a multiple choice question. Option A, do I need a will or a trust? B, what is probate and how do I avoid it? C, how do I avoid estate taxes? D, should I transfer my assets to my children now? E, can I protect my child's inheritance if they get married or divorced? F, can I preserve my estate for my kids if my spouse remarries? All right, I see many of you already voting ahead of time. That's great. Remember, this poll is anonymous, so feel free to express your thoughts. All right, I'm
Okay.
going to give it a few more seconds and we're going to end the poll. Excellent. Nidia, we can now share the results in the next slide.
Okay, and so there you see the results are, let's see, okay, 82% of you shared that, can I protect my children's inheritance if they get divorced? So that seems to be the issue of greatest concern among us. But then the second contender is, do I need a will or a trust? And it seems like everyone has an interest in everything else. And so the good news is that no matter what question you wanted to find out about tonight, this is exactly what we're going to be talking about. And we will be talking about each and every one of these questions. So even if your concern was not the leading concerns, no worries, because this is exactly what we're going to be talking about tonight. Now, before we get started, I want to tell you a little bit more about me. And on the screen, you can see a lot of stuff about my education, my prior experience, my affiliation, and my memberships and what have you. But I think more interesting stuff about me is the fact that I have two sisters. There they are on the upper middle of the screen. I am the middle one, and we do sisters trips very frequently. I am the proud aunt of five, three boys and two girls, two nieces and three nephews. And I raised two girls, the daughters of a client that got deported. And so I raised them until I was able to reunite them with their mom. They are right there in the center of the screen. I'm also an avid pet lover. At the bottom of the screen is my new little puppy, Jada. She is a Rottie. She is just beautiful, awesome. She'll be turning 2 soon. She is a rescue. And on the upper is my other four-legged love, Ranger. Ranger is a retired racehorse, and I like to brag about the fact that he has Secretariat in his lineage. He is just absolutely gorgeous. His favorite snacks is carrots, and so I do a lot of spoiling with Ranger. Now, other things that you should know about me is the fact that I was born and raised in New York. I've been living in Florida for over 30 years and in South Florida for over 20, so that makes South Florida home. But the most important thing that you should know about me is that I love to serve. From the age of 8, I was saying crazy things like, I want to be the voice of the voiceless. What little child says stuff like that? But I did. I always wanted to advocate for others. And so the way that I chose to do that was by becoming an attorney. I love what I do, and I love to serve. Now, um, uh, other things that you should know about me, the most important reason I do what I do, I was born to be an attorney, so there's no doubt about that. When I opened my firm in 2002, the Terry Schiavo case was very prominent. For those of you that are not familiar with the Terry Schiavo case, Terry was 26 when she collapsed from heart failure. It was based right here out of Tampa, and she lost consciousness immediately, and she never regained consciousness. After several years of Terry being in a vegetative state, her husband wanted to remove life sustaining devices, and her parents opposed. And from there ensued a 15-year, very, very public battle in the courts. All the courts got involved. The United States Supreme Court. It actually even went up to the Florida legislature. So it was very public and very ugly, because when people go to court, what they do is they say ugly things about each other as if that's going to score them points to win the case. And I just remember thinking how sad it was that the two people that Terry loved the most were now fighting each other because of Terry, and they both had the best of intentions. And I don't know what Terry's selection would have been. Would she have wanted to remain alive through life sustaining devices or not? But I'm pretty certain that Terry would have never wanted to be the public spectacle that she became, or she would not have wanted to have the people she loved the most fight each other so publicly. And I just found that very tragic. And when people called the office to plan, they would always ask for a will. And I just remember always thinking a will would not have prevented what was going on in the Terry Schiavo case. And that's a true tragedy. So it was always really important to me from the time that I opened the doors of my firm that I could tell people about what estate planning really was about and all that you could do through estate planning. So my quest in that path started inspired by the Terry Schiavo case, but then in 2015 it hit a little closer to home, as was the case with Terry Schiavo, a very good friend of mine. Same thing. Out of nowhere, she was in her 40s, collapsed. She had an inoperable brain tumor, and in my friend's case, Ella, what happened was that her mom took custody of her, and her mom, which would normally be a good thing, but Ella and her mom did not get along. In fact, they had been estranged for over 10 years because Ella's mom did not approve of Ella's life choices, one of which included the fact that Ella was living with her boyfriend and not married, and that was not acceptable to Ella's mom. So they didn't really get along. But when Ella lost capacity, Ella's mom took over Ella, and what ended up happening was that Ella's mom did not allow any of us, including her boyfriend, with whom she had been, they had been together for 14 years, living together for 10. And I just found that so tragic. And I remember thinking that I never talk about these things with my friends because this is work. And I just couldn't shake that feeling. And the difference between what I do when I open the doors to my firm and what I do after the Ella experience is that we launched an education center as a result of that very personal experience. And you are now the participants of the firm's education center. We are an education based law firm because we believe that when people are knowledgeable about estate planning, they can participate in creating the best estate plan to protect what matters most to them. So a little bit more about the firm. Like I said, we were founded in 2002, and since then we have helped countless families plan, and we have assisted with millions and millions of dollars in the transfer of assets. But sadly, we have also witnessed many individuals and families that we have not been able to plan because, as was the case with Ella, timing is critical. The time for planning is when you don't need it, so that when you do need it, it is available. And the one thing that I know for sure you will learn about more about tonight is that we approach estate planning very differently because we focus on the concerns that families have. A little bit more about the firm. The ladies that you see there are Maria. She is to the left. She is the finance and operations coordinator of the firm. Doris Mascarella, she's in the center, and she is the business development director. And Maciel Leiva, who is joining us tonight, is the client services coordinator. Now, the reason I want you to meet them is because when you call the firm, these are the ladies that you will most likely be speaking with. Doris will be following up tomorrow, and then Maria and Maciel are the ones that receive clients and receive calls into the firm. So they are the gatekeepers of the firm, and it is always good to put the name and the face together. Now, I've been practicing, like I said, for 30 years. And one thing that I wanted to share tonight, and the reason we bring forth these presentations, is because during the journey of practicing law, I have met with many clients, and they have shared common concerns. And so these are the concerns that clients tell us. Clients tell us that what they want is to be in control of passing their hard earned wealth without any government interference. And they also tell us that they want to avoid any unnecessary taxes and fees. I think we can all understand that. Huge concern with clients is that they want to avoid going broke from nursing home and other crushing medical expenses if they have too much to qualify for government benefits, or will they have too little to not be able to afford the care that they need. So that's a huge concern for many of our clients. They also want to responsibly distribute the inheritance that they leave behind so that it could serve as a blessing and not as a hindrance to those that they want to give their wealth to. They want to make sure that whatever they leave behind will not create chaos. So they want to make sure that they manage their affairs in such a way that peace can remain in their family and not discord or heartache for their loved ones. And lastly, a huge concern with our clients is that they want to be remembered. They don't just want to be a name on a family tree. They want to pass on their values, their wisdom, their life stories. So there you have it. These are the six concerns and the six wants, the six desires that our clients constantly tell us about. They want to be in control, keep government out of their affairs, minimize costs and fees, plan for long-term care, be responsible about the distributions, avoid any chaos, and leave a lasting legacy. And that brings us to poll question number 2. Maciel, can you launch that for us?
Yes, so poll question 2 is asking how much estate planning have you done? Option A, I have done nothing. B, I have a will. C, I have a trust. Or D, my plan is to spend it all before I go. All right, I see many of you already voting. That's great. We have a variety of answers. All right, I'm gonna let it continue with a few more seconds, and then we'll close the poll and share the results. Okay, Nidia, can you share the results?
Absolutely. So there let me see if I can get this done. Right, there you go. So this is a great audience because 71% of the persons in the audience have done nothing, and we do have some that have gotten a good start. Some have a will. Only 2% have a trust, and we have 15% that want to exercise the parents' revenge of spending it all before they go. And so the reality is that some of you have had a good start. And so what I want to do is I want you to take stock of your answer, and let's see how that changes through the presentation. All right. So I told you earlier today that you are going to learn tons. And so that's part of what I really want you to do. I want you to become well versed in estate planning because it is the best way to plan and protect what you really love. But my rhetorical question to you is knowing enough? And so one example that I like to use is what does it take to lose weight? Well, mainly two things. You have to exercise and diet, right? Move more, eat less. Well, now that you know how much what it takes to lose weight, I ask you this: how much weight have you lost just by knowing? And the answer is we don't lose weight just by knowing. In order to lose weight, we got to get into action. We have to do the things that are going to cause us to lose weight. And it's the same thing with estate planning. So you're going to learn tons tonight, but knowing is simply not enough. And so I'm going to tell you a secret. My mission tonight is to motivate you into action so that you can take the affirmative steps of planning to do what is best, what is in your family's best interest. So knowing is simply not enough. Taking the next step is my true mission tonight. And so for some people, they may ask, well, do I really need to plan, and do I really need to plan now? And the answer is yes, estate planning is a universal need. Now, here are some of the most frequently expressed myths. Oh, estate planning is more appropriate for older folks. Or I've also heard estate planning is only for the wealthy. I don't have enough assets. I've also heard I have a will, I'm all set. I've also heard, well, I hold my assets jointly with so and so. For married couples, it's typically the spouse. And I've also heard, oh, it's too expensive. Now, if this was a true or false, it would be a big fat false for each of these myths. They are exactly that, myths. They are not true. In fact, all of these statements are false, and I'm going to be discussing that tonight. Now, one thing about estate planning is that the primary focus is money. And I think that that's good, right? Because money makes the world go round, or so they say. And then Tina Turner tells us what's love got to do with it. So, yeah, we're going to talk about money. And we think that focusing on money is not necessarily a bad thing. But is that what really matters to most of you? Is planning to preserve, transfer, manage financial wealth enough? And I don't think so. I do not think is enough, because when we ask our clients what is most valuable to them, what they tell us is that what's most valuable to them is family, health, friends, values, skills, relationships, accrued experiences. And so in our world, in our firm, this is true wealth. So it's not just money. True wealth is comprised of all these things. And so, stated differently, let's assume that we divide wealth into four different categories. The first category is your values, and this category is the foundation that we build our lives on. It includes our family, our health, our talents, our background, and attitudes. The second category would be experiences, and this is the sum total of all our experiences, and it includes our formal and informal education, our relationships, our work ethic, our commitment to spiritual beliefs or practices. The third category would be community. And this is our contribution to society, our responsibilities as good citizens and neighbors. And this can include financial, charitable gifts as well as volunteer work. And let's not forget about the contribution that we all make in the form of taxes. And then the last category would be financial. And this is the category that most people think about when they think about the topic of estate planning. And this financial category includes our collective financial assets or material wealth, or possessions, or stuff. Now, if I were to ask you which of these is least important to you, which one is it? Well, for most people, financial is the least important. Now, I know I have skeptics in the group, so I'm going to ask it differently. Let me ask you this. If I were to give you money in exchange for your health, would you take the money? And the answer is no, because most of us value health over money. Okay, well, what if I were to tell you, well, will you take money in exchange for your good reputation? Once again, the answer to that for most of us would be no, because we value our good reputation more than we value money. One last example to prove my point. If I were to tell you, will you trade a person in your life for money? Excluding teenagers. And the answer to that is no, because we value people in our lives more than we value money. And so the reality is that money is a necessary evil. It's what we use, but it is definitely not the most important thing in our lives. And so, because money is not the most important thing in our lives, the focus of an estate planning exclusively on money is not appropriate. It's simply not enough. Now, one more point that I want to make about the estate plans that we see routinely coming in and out is that I believe that most plans fail for one of two reasons. Either the documents are poorly drafted, or the concerns are the unique concerns of the families and each of its members is not properly addressed in the plan, in the documents that have been prepared. Now, what I'm going to do is I'm going to talk about all these concepts using the story of Wilma and Fred Stone. Now, Wilma and Fred Stone is a fictitious couple that I've created. They are they reflect the clients that come across our firm frequently, and so even though they are fictitious, they really do represent uh, a lot of the clients that we serve here at our office. Now, Fred is recently retired from FPNL. He worked for them for 30 years, and he is now retired, and he's going to enjoy the rest of his days with his beautiful wide bride, Wilma. Wilma is fixing to retire. She will be retired by the end of the year. She too worked as a school teacher for the county for over 30 years. So they will be recently retired, both of them. Fred got a step ahead of Wilma, and together their estate is worth approximately $700,000. The estate includes retirement accounts, real estate investments, life insurance, and other personal property. They don't think it's much, but we are going to see that it really is a lot. And they can do a lot with it. Now, you may be asking, well, what if I'm single? I've never been married. What if I'm widowed or divorced? Married more than once? Non traditional family? Will this apply to me? And the answer is yes, it will apply to you. Well, what if I'm young with minor children? Will it apply to me? And the answer is yes, it will apply to you too, because what we're going to be talking about tonight are principles of general applicability. And so, regardless of your marital status, of your stage in life, these principles will apply to you. However, the other reality is that the planning needs to be tailored depending on the stage of life in which you're in. So, Fred and Wilma's planning 30 years ago, when they both worked outside the home, did not have many assets, and may not have had children, would be different than, let's say, 25 years ago when they already had two children. And it's probably going to be different depending on the stage of life that they're in. So I'm going to ask you a question. What do you believe is the most important part of planning? Now, write your answer down, because as we go through this presentation, I'm going to ask this question again at the end, and I just want to see if your answer differs. All right. So I want to introduce you now to the children of Fred and Wilma, Peggy and Bobby. Now, Peggy is an all star, straight A's from elementary through college. She is a practicing CPA. She has been practicing, she's been a CPA now for 3 to 4 years. She is married. She married her high school sweetheart. We're going to meet him in a little bit. And together they have two children. One of her children is a special needs child, and that's a concern to Fred and Wilma. We also have Bobby. Bobby is very different from Peggy. Bobby was a rebel growing up and remains a rebel. He is in and out of jobs. He gets fired from one, quits from another. He borrows money from everyone, pays no one, in and out of relationships. And he also has a substance abuse problem, and that might be the source of all his problems. Fred and Wilma have tried helping Bobby out many times. It's never taken for a long time. And so Bobby and his reckless living is a concern to Fred and Wilma. They also have pets. They have Flynn, the dog, so his name is Flintstone, Sweet Pea, and Dino. Now, what are your planning options? Well, again, Fred and Wilma, 25 to 30 years ago, when they had minor children, little to no assets, or Fred and Wilma today, where they have some assets and young adult children, or perhaps the stage of life is Fred and Wilma in the future, worried about nursing home and long term care. And so the point is that the planning options for all of us remain pretty much the same. We can spend every last dollar, or we can die intestate. Dying intestate means that you do absolutely no planning whatsoever. And so what happens is when you pass away, your heirs, your family would have to go to probate court, and in probate court the court takes care of retitling the assets and distributing the assets to your heirs. And we're going to be talking a little bit more about probate later on. Creating a simple will, which is what most people want to do because wills are very popular. When you create a will is a document that basically activates at death, and it says, I leave my stuff to so and so. But if you have a will, you also would have to go to probate court because the court would be the entity that changes title to the assets. So if you do absolutely nothing, or if all that you have is a simple will, both things will end in probate court so that the court can retitle the assets to the beneficiaries or heirs of the person that passed. Another planning option is to put everything in joint tenancy. Now, one of the very early cases that I read when I was in law school was about an older lady who had been diagnosed with a fatal disease and told that she only had months to live. And so she had heard about the horrors of probate court, and she wanted to transfer her assets to her children so that they would not have to go through probate court. So what she did was she transferred all her assets to her oldest child, who was also the responsible child, so that later on he could share the assets with his two other siblings. Well, true to science, she did pass away several months later, but fortunately, they avoided probate court because they had managed to transfer all the assets to the older responsible son. Well, what do you think happened? What do you think happened with those assets now that the older responsible son had title to them? Well, some of you might start thinking that the son got greedy and did not want to share it with his siblings. And yes, I've seen that happen. But in this case, what happened was that the older responsible son died just 2 weeks later in a construction accident. And so his wife of less than a year ended up inheriting all the assets. Now, she did avoid probate court, but she inadvertently disinherited her children. And you may say that what she should have done was to add all her children in title, not just the older responsible son. Well, we love our children dearly and we want to bless them equally, but you do not know the credit history of your children, or perhaps it was minor children, and leaving any inheritance to minor children could have caused another guardianship or something like that. So the point I'm trying to make is that in addition to tax consequences, that transferring assets to children, or creating joint ownership of assets, in addition to the tax consequences, it's very risky because if any person on title has creditors, those creditors can go after any asset that debtor has. And so owning assets jointly with someone could make that asset toxic. Now, another planning alternative is create a bare bones trust, and this I see frequently prepared by attorneys that don't do this as a specialty, or worse, do it yourself documents that you can download off the internet. And in there, what I see is two things. The needs of the family are not specifically addressed because these are cookie cutter boilerplate documents, or the documents are so poorly drafted that not even the definitions are consistent throughout the documents. So that is an option that a lot of people exercise, believe it or not. Or the last option is to create a comprehensive plan that is tailored to your concerns and considers the specific and unique needs of your family, which is what here at our firm, that's what we do. And we refer to that as true wealth planning. Now, Fred was very anxious to get started with his retirement routine, so he got started on a very rigorous exercise program and found himself suffering from a mild heart attack. Now, it wasn't too bad. Wilma was there. She saw the whole thing happen and she called rescue. They came immediately and they helped him out. He spent a couple of days in the hospital, in part for observation. He was sent home and life went on. But it didn't go on in the normal fashion because now Fred and Wilma were rattled by that experience and they realized that they needed to do something. They didn't have any of their affairs together, so they wanted to go ahead and do some type of planning. And so what they did was they didn't attend a webinar like you're doing. They contacted the only attorney that they knew. The only attorney that they knew was the attorney that had done the closing on the property that they currently live in. And so they paid him a visit, and the conversation went something like this. Um, uh, the conversation went something like this. Fred tells the attorney, well, I want to leave everything to Wilma. And if Wilma predeceases me, then I want to leave everything to the kids. Wilma says, well, I want to leave everything to Fred. And if Fred predeceases me, then I want to leave everything to the kids. The attorney says, oh my God, what you referred to has a name. That's called a sweetheart will. I leave everything to my sweetheart. I'm no estate planning expert, but I can definitely do a sweetheart will. They all think that it's the greatest thing. They shake hands and a sweetheart will gets prepared. They come back, Fred and Wilma come back a couple of weeks later, they sign it, and they are feeling so pumped up about the fact that they got this done that they're just going to go ahead and get the rest of it done. And the rest of it is basically planning for funeral expenses. So on the way home, they stop at a funeral home and they make funeral arrangements. Life is now set. They've done all the estate planning that they thought they needed, and now they can, relax about that. It's off their to-do list. Well, life goes on, and 9 months later, what do you think happens to poor Fred? Well, some of you might have thought he died and killed him off. Nope, that's not likely. In fact, what happened was that Fred has a second heart attack, and this time it becomes much worse, so much so that this time Fred becomes disabled. Now, the reason in my story, he becomes disabled is because we have a 70% chance of suffering some form of disability and needing long-term care before the age of 60, by the time we turn 65 and older. So 70% of us will need some form of long-term care after the age of 65. And so the fact that Fred would need long-term care is very probable. Now, other questions that arise with respect to long-term care is, what is long-term care? What am I talking about here? Well, long-term care has two components. The first component is a medical component, but the more pervasive component is a non-medical care, the daily living activities like bathing, feeding, toileting, transporting. All those things are included in long-term care, which is why it's so expensive. And of course, long-term care can be provided in many settings. And again, I want to remind remind you of what the numbers are. 70% of persons over the age of 65 will need long-term care. And the average cost in South Florida for long-term care is $10,455. That's in excess of $125,000 per year. The second question, now that I talk about money, is how do you pay for long-term care? And the answer to that is that there's only really 5 ways to pay for long-term care. The first way is you pay for it out of your own money. And so at the cost of over $10,000 a month, uh, some of us would need to be really prepared for that because that's a lot of money. So not all of us are going to be able to afford it. Another possibility to pay for long-term care is to buy long-term care insurance. Now, the insurance premiums are relatively inexpensive when you're young, but when you start to get of age, they become more expensive. Now, who thinks about these things when you're young? And the answer is few of us, if any of us, think of this stuff when we're young. We start to think of this stuff when we start to become older, which is when premiums start to get more expensive. So long-term care insurance is an option, but for some it might be cost prohibitive. Applying for limited Medicare benefits, Medicare will pay the first 20 days and then it does a small copay for the next 100 days. There's nothing long about 120 days. So counting on Medicare is not appropriate. Medicaid does pay for long-term care, but in order to qualify for long-term care, you have to be impoverished. There's a means test component to Medicare, and so you cannot have assets if you want to qualify for Medicare. And then qualifying for Veterans Aid Administration, the Veterans Administration also has a means test component, but it is way more generous than the Medicaid program. So there you have it. Those are the 5 ways to pay for long-term care. Now, the second question, the third question that comes up is who is going to handle Fred's affairs now that he is disabled? Well, it could be Wilma, or it could be Bobby or Peggy, or it could be anybody else. But the point is that when Fred and Wilma planned, all that they planned was a will, and a will does activates a death, so it does absolutely nothing for incapacity. They had no planning for incapacity in spite of the fact that the probability of incapacity is so high. So, because they only had a will, who will handle Fred's affairs now that he is disabled will be decided by the courts. Now, in Florida, the legislature, the law says that preference goes to the wife. So, if the court agrees that Wilma could be a proper guardian and custodian for Fred, then the court will appoint Wilma. But the bottom line is that the guardianship process will have to take place in order for the court to appoint a guardian to handle Bill's affairs. So to handle Fred's affairs. So to use any of Fred's money, even for his well-being, will need to have permission and approval by the court. So I've alluded to this a little bit, but why should you avoid guardianship? Well, because it's a nightmare. It's humiliating. You're going to be declared to be incapacitated and incompetent to handle your own affairs. The court is in control. It's time consuming. Personal information is disclosed and it is expensive. Very, very expensive. Now, eventually, Fred passes away. And so, what do you think happens now that Fred passes away? Well, Fred only had a will. So, what we say in our firm, if I were to ask you to complete the phrase, when there's a will, well, most of us would say when there's a will, there's a way, but no, when there's a will, there's a probate. All that Fred and Wilma had was a will. So when Fred passes away, they have to go back to probate court in order for the court to transfer title to the assets, to pass them the way that Fred had said he would want the assets transferred in his will. So, in order for Fred's assets to transfer to Wilma, the court will need to do that. So it's really an expensive way to substitute your signature to transfer your assets. In probate, the court will also resolve any disputes that arise, and the court will require that creditors get paid. Why should you avoid probate court? Well, because it is expensive, time consuming, open to the public, and if you have properties in other states, you're going to be subject to multiple probates because, for example, Florida courts only have jurisdiction over Florida properties. So if you have property in Georgia, you would need to do an ancillary probate in the state of Georgia so that a court in of Georgia jurisdiction can transfer the assets that are under its jurisdiction. And lastly, what about taxes? Well, there is this pesky little thing called estate tax, also referred to as death tax or transfer tax or inheritance tax. Currently, we're not too worried about it because there is a $10 million exemption. So, what that means is that the estate tax applies to all the assets at the time of death, but the first $10 million are exempt. Adjusted for inflation in 2021, the exemption really is 11.7 million. So so we're not worried right now too much about the estate tax, and in the case of Fred and Wilma, it doesn't really apply. But I would say be careful because the estate tax exemption changes frequently, and in fact, every administration they just can't resist themselves. They have to touch it, and the current administration has already said that they intend to reduce the exemption to $3.5 million. We just don't know when. Now, another thing to be careful about is that the estate tax exemption of $10 million only applies to US persons. Non US persons only have a $60,000 exemption. We see a lot of non US persons in our office that get zapped by this because they buy real estate or they have other property in the US, and it will $60,000 accrues very quickly when you have real estate or or you're an investor. So careful for non-US persons. And then I would say also be careful because other states have estate tax, and the exemption is much lower than the federal exemption. Florida does not have an estate tax. So, back to Fred and Wilma, we're not going to worry about the estate tax in their case. But was anything done to remember Fred? Or will he become just a name in the family tree? Nothing was done to capture Fred's wisdom, his life stories, or his experience. So it looks like Fred, in generations to come, will only be remembered as Fred with nothing more. But it gets worse because the top three concerns after the death of the first spouse is that the surviving spouse will remarry. And we've all heard the stories about how a surviving spouse that remarried lost the inheritance of that would have gone to the children from the first marriage for lack of proper planning. So that's a concern now that Fred has passed away. If Wilma remarries, the the inheritance that Fred would have wanted for Peggy and Bobby could be lost to remarriage. Nothing was done in this case to protect any of the wealth that Fred left to Wilma to protect that from creditors and lawsuits. So that remains exposed, and absolutely nothing was done to help Wilma plan ahead in the event she wanted to qualify for nursing home. So his wealth, Fred's wealth, was not set aside to better posture Wilma to qualify for Medicaid. So after the death of the first spouse, or if you are single, these are valid concerns that can all be addressed through planning. So back to Wilma, now that Fred is gone. Wilma, I'm introducing you now to Barney. Barney is the longtime neighbor of Fred and Wilma, and he lost his wife Betty less than a year ago. So he has been extremely supportive of Wilma because he understands the pain of widowhood all too well. But the fact is that Ralph and Wilma started hanging out together and eating cookies and teas, and now they're having wine and cheese, and there's talk about a movie. And folks, you know where I'm going with this. So because all that Fred and Wilma did was a will, the concern is that if Wilma remarries and marries the Barney, the inheritance that would have gone to Peggy and Bobby could be lost to remarriage. And we believe that that should be protected, because whatever wealth you accumulated during your lifetime should stay in the family, in your family, and a well drafted estate plan can protect that wealth. Again, nothing was done to better posture Wilma should she need to qualify for Medicaid to go to a nursing home. And nothing was done to protect Fred's assets from becoming subject to creditors in the event that Wilma gets sued. I always tell clients that we are one accident or one illness away from having creditor issues. So, proper planning can help preserve assets in the event that the unwanted happens. And that brings us to polling question number 3. Maciel, can you launch that for us?
Yes, Nydia. Poll question number 3 is saying, I still need to plan to protect my family from option A, the judicial process of guardianship and or probate, B, protecting the inheritance for and of my children, protecting from remarriage, divorce, lawsuits, and creditors, C, the chaos of leaving my affairs a mess, or option D, not passing along my life values and stories. All right, I see many of you voting. Remember, this is anonymous, so feel free to share your thoughts here. Okay, I'm gonna give it a few more seconds, Nydia, and then we can go ahead and share the results. All right, everyone has voted now. I'm gonna end the poll. Can you share the results, Nydia?
Yes, ma'am, I can. Okay. And so the huge winner is protecting the inheritance for any of my children from remarriage, divorce, lawsuits, and creditors. And that was followed by the judicial process of guardianship and or probate. But the reality is that each of these each concern had people that had that concern. And so I would say that the good news is that no matter what your concern is, what I'm going to do is show you how you can avoid all of these concerns. And we're going to do that right now. So let's get started for this ride. Wilma has the whole estate now that Fred's passed away. $700,000. And the reality is, we know anecdotally that absent any crushing medical expenses or bankruptcies, wealth grows. So what we're going to do is we're going to assume that Wilma now has $1 million. It grew from 700,000 to $1 million in the span of 10 years. Eventually, Wilma does develop Alzheimer's, and the reason for why I include that in my story is because up to half of the elderly end up in a nursing home before death, because up to half of the elderly are unable to handle their affairs. And what happens? Well, she develops Alzheimer's. Now we go to the second guardianship. And so, again, who is going to handle Wilma's affairs? And I remind you that we end up in a second guardianship because all that Wilma had was a will. Nothing was done to avoid the guardianship. So now that we are in a guardianship, which of the children will the court likely appoint? Well, in the case of Fred, I had told you that the statutes gave the spouse preference, but in the case of Wilma, the statute would give the children preference. Well, which of the two? Heaven help us if the court chooses Bobby as the guardian for Wilma. That would be a disaster. But the reality is that they both have equal priority. So that is a risk. Eventually, Wilma passes away, and welcome to a second probate. Death taxes we're not going to worry about because Wilma's estate was only $1 million, and currently the exemption is $10 million. So we're not worried about that. But nothing was done to preserve Wilma's memory, any of her wisdom, no, none of her values. So chances are that in a generation or two, she will just be a name on the family tree. Now, I can't quantify for you how much peace of mind it would give you and your loved ones when you plan, but I can quantify it for you in terms of dollars. So let's take Wilma's estate, which was valued at $1 million when she when she was stricken with Alzheimer's. The cost for the nursing home was $324,000. How do I come up with that number? Well, the average cost for nursing home in South Florida is $10,455, and the average stay in a nursing home is 2.8 years. So when you combine the two, the average cost would be $324,000. So at the end of both deaths, let's assume that the estate it has a value of $675,000. Now, notice that I'm not taking into account any of the expenses for Fred. I'm not taking into account any of the guardianship costs, the probate cost, or the long-term care costs for Fred. We're neutralizing that, and we're not bringing that into the picture. We're only taking into account the cost for Wilma. So I keep saying that probate is expensive. And so here you have it. This is what I mean by that. The cost of probate ranges between 6 and 10%. So I'm going to use an average of 8%. And so when the value is 675,000, the cost of probate is approximately $54,000. So the nursing home cost and the cost for probate have a total cost of $378,000, which leaves approximately $628,000 for distribution to Peggy and Bobby, each getting approximately $311,000. But are your beneficiaries ready or prepared for an inheritance? Do they have the financial maturity? And let me ask you this, knowing Peggy and Bobby, should they receive the inheritance in the same way? Well, the top three concerns after parents are gone is that the wealth of their heirs will be dissipated to creditors and predators, or to the divorce of their children, or the financial lack of maturity of their children. So those are the top three risks that parents face after the loss of after they're gone. Now, I had promised to introduce you to Peggy's husband, and there you have it. He is a parent's worst horror, a nightmare, and his name is Larry. I call him Lazy Loser Larry because that describes him better. Now, they were high school sweethearts. Peggy grew up, he not so much. He's always thinking about a get rich quickly scheme, except that it never comes to fruition. So, Peggy has just about had it with him. And if she gets divorced, that inheritance that she could get from her parents would be in jeopardy because lazy loser Larry could walk away with up to half of that. And have we even considered Bobby? He is a walking liability factory. I mean, any type of wealth in his hands could lead, his first investment would definitely be a souped up car. So, with his behavior, there could be a car accident, drug abuse. He's a spender, creditors. So, frankly, I just feel like we need to protect Bobby from Bobby himself. So, with the planning that Wilma and Fred did, let's summarize what a bad estate plan looks like. They used the will, which means that they had no protection for living or death probate, no protection for remarriage, no protection for divorce of their children. no protection for lawsuits and creditors of their children, no planning for long-term care or nursing home, no planning for federal or estate death taxes, no planning for special needs beneficiaries, and there was no way to preserve their family values, life stories, or their wisdom. So there has to be a better way, and folks, there is. The answer is really to use living trusts as the cornerstone for your planning. So, what is a living trust and how does it work? Well, a living trust is a complete substitute to a will. It helps to control distributions, it provides management during incapacity, it allows for tax planning. In fact, for married couples, the exemption of tax free transfers can be doubled. It allows for remarriage protection. It allows for creditor and lawsuit protection for the beneficiaries. For divorce protection, you can actually include special needs planning. And when combined with other documents, it can provide protection for long term or nursing home care, and that's more frequently termed Medicaid planning. Now, other names for a trust, living trust, like we've been calling it, revocable trust, grantor trusts. Now, one size does not fit all. So, we don't want a trust that's only going to address the concerns of probate. We don't want a trust that's going to be a cookie cutter. It needs to be customized and tailored to the unique needs of your family and each of its members. And we want to make sure that the trust will have tax efficiency and provide all the protections, including remarriage and divorce protection. So, what if Wilma and Fred had known what you're going to know tonight? What would their to-do list look like? Well, they would have started by educating themselves and finding out what they need to know to best protect their family. They no longer think that creating a will is the way to go. They're going to consider the living trust, and they are definitely going to plan for incapacity. And in doing so, they're going to consider asset protection and long-term care needs and the protection of the inheritance for each of their children. Once they do that, they can plan vacations and focus on their retirement. So let's see what would happen to Fred and Mary, to Fred and Wilma when they choose to plan the correct way. And so tonight, what I'm going to do is I'm going to introduce you to what I refer to as true wealth management. And this is designed to protect the whole family, including family values and history, not just while you're alive, but for generations to come. There are three main components. First includes the financial assets and protect them from guardianship, probate, remarriage, lawsuits, creditors, unnecessary taxes. But at the same time, it would allow your heirs access to the funds in a responsible way to shield them, and the assets can be shielded from nursing home or other long-term care. The second component is that it gives your family the means to capture biographies, life stories, wisdom, and values for future generations. And thirdly, and perhaps the most important, is that it helps to avoid family feuds by making sure that all of your decisions, including the planning for medical directives and even distribution of non titled assets like family photos, memorabilia, miscellaneous family treasures, so that all that can be distributed to the heirs the way that you designate it, the way that you designate, providing clear written instructions. And this entire process not only creates a responsible protection of wealth while you're alive, but it also allows for the orderly transfer of your assets when you pass away. And with this planning, you can prepare, educate, and even provide incentives for your heirs to improve themselves before family funds are available to them. And this is a legacy that you want to create within your family, regardless of your financial wealth. And so to make this happen, you can't just download documents and fill in the blanks, or just have an attorney that doesn't specialize in this type of planning do cookie cutter documents. So, and I would say that this can't just be done with one document. it requires an entire host of supporting documents as well. So for the rest of the webinar, what I want to do is I want to show you how all the problems that Fred and Wilma faced can be handled with a well-designed plan that includes customized documents, among which is the trust that I mentioned earlier. And that's the opportunity that I want each of you to have tonight. So in a trust, who are the players? Who is the cast of characters? So the cast of characters includes the trustor. The trustor is the person that creates the trust and that transfers the assets into the trust. The second player would be the trustee. The trustee is the person that manages the assets that are in the trust. And the beneficiaries is the person or persons that benefit from the assets that are being managed in the trust. And you can be all three, which means that you would have the gift of total control. It would be business as usual. So, what I tell people is to think of the trust as if the trust is a company. A company has perpetual life. You are the president and you're putting your assets in the trust. And you also have a vice president. So, if you cannot serve the functions of president, you've already decided who the vice president is. Same thing with a trust. You are the trustor, you're the trustee, the president is the trustee, and you've already appointed a vice president. And that is the reason why you can always stay in control, because you decide who is managing your affairs and not a court. So in a trust, the magic is to make sure that the assets are funded into the trust, that the assets are transferred into the trust. And so when the assets are titled in the trust, that is the reason you don't have to go to court to retitle the assets or to allow any management of the assets, because you've already appointed the successor trustee and you've already transferred the assets into the trust. So it provides protection in the event that you become disabled or die. So it provides protection for incapacity without court involvement. It's private, so nosy neighbors don't snoop in. It's cost effective, time efficient, and you make all the decisions. And it helps to protect your spouse, your children, and your grandchildren. So a lot of people say, well, it's business as usual. Why should I have this? Well, because it's a just in case device that provides all the protections that we just talked about. So in our case, when Fred has the second heart attack and becomes disabled, there is no need to go to probate court. When Fred passes away, there is no need to go to guardianship court. No need to go to court, either probate or guardianship, because the assets had been transferred to the trust and Fred had already appointed and designated Wilma to be the successor trustee. So even though he was incapacitated or when he passed away, the assets were being managed by Wilma. Now, what about how will Fred be remembered? Well, first of all, we're having the conversation. And second, we are providing tools so that so that you and your family can use these tools to capture who Fred really was. So the conversation is had and the tools are provided. And with respect to taxes, once again, the estate of Wilma and Fred is below the exemption amount, so we're not worried. But we do know that Congress likes to tinker with this tax very frequently. So there is going to be language in that trust so that we can exercise the option of doubling the exemption if that's what we need to do, to make sure that the estate tax is minimized as much as possible. This time, when Barney comes around, you know what I'm going to do? I am going to not worry at all. I'm going to wish them well, because when we planned for Fred and Wilma, we made sure that if Wilma was to, that if either one of were going to remarry, that the inheritance that the first marriage had created for their children will not be lost to remarriage. So I am going to wish them well, and I hope that they live a happy life together. And we're not going to be worried about posturing Wilma to qualify for Medicaid, because we are taking aside Fred's assets and preserving them so that they will not be counted towards Medicaid and disqualify Wilma. We're also protecting those assets in the event that Wilma does get sued so that those assets will never be lost to creditors or lawsuits. Now, this time when Wilma develops Alzheimer's, we are not worried. There is no concern because the assets have been transferred and Wilma already designated who her guardian was going to be. She knew that her responsible daughter Peggy was the one that she would want in charge, and that's what her documents stated. So we don't have to gamble on which of these two the court will appoint. No court involvement. The decision was already made by Wilma, so she remains in control. And what about the cost of long term care and assisted living? Well, Wilma had done the additional planning. And so that means that uh, she will be able to save approximately $324,000 because she will be eligible for Medicaid benefits. Again, I remind you that in order to do Medicaid planning, that is above and beyond the basic planning. But I do like to mention it because it is definitely worth thinking about. And this time, when Wilma passes away, we are not concerned with going to probate court because remember, the assets were already transferred into the trust. And so that means that the successor trustee that Wilma appointed will be in charge of distributing of managing the assets and making the distributions in the manner that Wilma had designated. And we're not worried about whether Wilma will be just a name on the family tree because one, the conversation was had, and two, the tools to capture that were provided. Now, how are we doing so far? Well, so far with the planning, we have addressed Fred's guardianship and probate, the fear of Wilma's remarriage. We have protection from Wilma's lawsuits. We have prepared to qualify Wilma for Medicaid. We have taken care of Wilma's guardianship and probate. And the values and life stories for Wilma and Fred were both captured. So, what's left in our plan? Well, my concern up to until now that has not been addressed is the real possibility that Peggy could get divorced and frankly Bobby's reckless living. So how are we going to handle that? Well, I remind you that when we had the will, the distributions were half to Bobby, which would have been approximately 310,000, and half to Peggy, which would have been approximately 310,000, because we had a million in the estate, cost of about 378 million, which left about 310,000 for each. But what I say is that outright distributions is like spilt milk. Once that milk is spilt, you can't, it's useless. You can't use it. You can't capture it again. So I don't like doing distributions outright because once out, that milk is no longer good. So what I always tell my client is don't give your inheritance to your kids, leave it to them in a trust. And so, option one would be we start out with $1 million and we create two separate trusts, sub trusts really, one for Bobby and one for Peggy. Now, Bobby and Peggy are very different from each other. Does it make any sense to leave them their inheritance in the same way? And I say, heck no, it doesn't make any sense to leave their inheritance in the same way. Peggy is responsible. She knows how to manage money. She knows how to handle her affairs. So for Peggy, I'm going to leave her inheritance in an unrestricted trust. Peggy is going to be her own trustee. But for Bobby, not so much. There is no way I'm going to let this man handle any money because I just fear what could happen. And so by doing this, what we end up doing is we end up protecting the wealth. When Peggy gets divorced from Lazy Loser Larry is going to walk away exactly with what he deserves, which is absolutely nothing, a big fat zero. So we do that by putting Peggy's inheritance in a trust that is separate and remains separate from marital assets so that it does not get commingled. Now, for Bobby, I am concerned about Bobby because, frankly, I feel like we need to protect Bobby from himself. So, for him, what we're going to do is a restricted trust where we appoint an independent trustee that will restrict any access that Bobby has to the funds that have been left for him. So, yes, the funds will be for Bobby's benefit, but not under Bobby's management. And so that's going to allow protection from divorce, lawsuits, creditors, and frankly, from Bobby himself. I mean, for crying out loud, he has a substance abuse problem. We don't want him to have access to any money, not if he doesn't shape up. But we do have hope for Bobby, so we can sprinkle incentives into his trust. Some of the incentives could look like having a full-time job, having, enrolling in some type of education with good grades, substance abuse treatment, counseling for gambling, whatever the needs are. You could sprinkle as incentives for your trust because the reality is that we love Bobby, we have hope for Bobby, we just don't trust Bobby. So we will get him trusted. How's that? All right. Now, remember how Peggy has a special needs child, and that was a concern to Fred and Wilma. And they may want to provide for their special needs child, as many of my clients do. Now, what we see is that a lot of people want to provide for special needs individuals in their family, and they leave the inheritance outright to them. But when you do that, it's really not a good idea because you could very well be preventing them from qualifying for government benefits to which they're entitled to. So if you have special needs individuals that you want to bless, the proper way to do that would be by funding a special needs trust for them. So never, never, never leave anything outright to a special needs individuals because you may end up disqualifying them from qualifying for benefits. So this is another option. Instead of leaving the inheritance to Peggy and Bobby, half and half, you could have a trust with three different subtrusts, the restricted trust for Bobby, unrestricted trust for Peggy, and the special needs trust for the grandchild. And notice how each trust would be funded with $333,000 as opposed to the $310,000, which was way less, divided by two when the planning was not done. And so the point I'm trying to make is that with proper planning, you can stretch the dollar more. And you can even plan for your four-legged. For all our clients, we ask them, do you have pets? Do you want to plan for your pets? And so many of our clients exercise that option, and you can even do that. So just amazing all that you could do with a trust. So I've shared with you what I do, why I do it. I want to share with you now how I do it. We have a four-step, what we call four-step true wealth planning system. The first step is to attend an education workshop. We are an education-based law firm, so we want all our clients to go through the process of learning about estate planning and the proper tools to use for estate planning. So congratulations, you've taken the first step. The second step is to set up a consultation with an attorney where we're going to talk about your specific unique concerns in private. And if you choose to do planning at that second step, the consultation, we design the plan right then and there. We value your time. So we don't want to waste your time. We want to make sure that we make good use of your time. So at that meeting, you're going to have all the information you need. You come ready, we will be ready and to answer your questions, and we will be ready to design a plan if you are ready to move forward. We then touch base with you to confirm all the information that we obtained. The consultation and the confirmation can be done in person or virtually. We like to do the consultation in person, especially now that COVID is a thing of the past or becoming a thing of the past. And we clients are really opting to do the confirmation online, which we think works really well. And then the fourth and final step is the signing ceremony, where you literally come into our office. We will have the proper witnesses and notaries for the documents to be signed. So, from consultation to the signing ceremony, it takes 2 to 3 weeks, depending on how quickly you get us the information. And you would then be fully planned, fully trusted, like we like to say. But we don't like to end it there. We want to make sure that the funding is done. And obviously, we want the relationship to go into the future. So we want to stay in touch with you. And we do this through updates and other events. And obviously, we welcome anytime that you may have questions that you would call on us. Now, what is in your planning. So what we all our documents have an introductory explanation. We feel that this is important for you because we do this every day, so we know what these documents are. But we want to make sure that if you have questions, 3 months down the line, 3 years down the line, you can go to your binder and find some answers there. And also for your agents, because you've been through this course, but perhaps your agents have not. And we want to make sure that they understand exactly what to do. So we also have instructions, and we provide you with organizational tools so that you could have everything in one place, and your agents, your successors, don't have to scramble looking around trying to figure everything out. Your portfolio would also include the main documents, which are the living trust, the pour over will, the property power of attorney, and the advanced healthcare directives. And all those documents are supported by ancillary documents. Now, again, I remind you that planning for long-term care does require additional planning, and not everyone qualifies for that. So, if you're interested in long-term care or Medicaid planning, we would have to do an analysis to see if you qualify for that. Now, going back to one of the first questions that I had asked you, what's the most important part of your planning? I don't know what you wrote down, but you may want to compare that to what we believe it is. We believe that the most important part of your planning is making sure that whatever is most important to you is covered in your plan. No cookie cutters, because you and your family are unique. Now, um, we believe that again, with the same tune that you and your family are unique. We do not we definitely warn you against having bare bones documents or downloading documents, because you want to make sure that your plan is something that is tailored to your family. And another warning is that a lot of people make the effort to plan, but then they don't pay attention to transferring the assets into the trust. Now, we always take the first step with our clients because we feel that funding is extremely important. I mean, that's the secret sauce. When I first started practicing in the area of estate planning, I would constantly come around unfunded trusts, and at first it was just horrific. I'm like, oh my god, this is malpractice. But no, folks, failure to fund is common practice. Most law firms do not walk their clients through the funding, and I understand there's only so much that we can do. You have to do some heavy lifting. So I really, really want to emphasize this, that you need to make sure to pay attention to the funding. We take the first steps with you, but a lot of it is going to be up to you. So that is one of the most common mistakes that I see. But think about this. If you go through the effort and expense of planning and you do not go through the effort, it doesn't cost any money to transfer the assets into the trust. You don't go through the effort of transferring the assets to the trust, you're going to end up with expensive paper, and we don't want that. So just make sure that you take the steps necessary to fund the trust. Now, what about pricing? Well, we don't like surprises, so we do want to disclose what the fees with our firm are. What I would say is that when selecting the firm that you're going to work with, make sure that it's a firm that's asking questions, that's listening to what you're saying, that you're comfortable with them. We do not believe that this is the kind of work that should require hourly fees. So make sure that you get your quotes up front. Now, in our office, for the total planning with all the protections, which include incapacity protection, probate and tax planning, divorce and remarriage protection, and creditor protection, the cost would be $5,345 per unit. Husband and wife are a unit. So if you're married, it's one fee of $5,345. If you're single, it's one fee of $5,345. Now, I know that $5,345 is a lot of money, so I get it, but I want to show you by comparing the cost for the failure to not plan. So if you do the additional step of planning for Medicaid, the potential cost for failure to plan could be in excess of $300,000 in the case of Fred and Wilma. And in their case, the probate fees were approximately $54,000. So when you compare the cost of planning versus the cost of failing to plan, I just want to put those side by side so that you can understand why it would be worth your while to plan. And in addition to the money, which I know we always like to make a reference to that, I also want to remind you of the additional benefits of planning, the protections that we've talked about: remarriage, divorce, lawsuits, creditors, nursing home costs, and special needs planning, planning for your own incapacity, tax planning, the privacy, the expediency, and just plain and simple being in control. And that brings me to poll question number 4. Maciel, can you launch that for us?
Yes, Nydia, this is poll question number 4, is the last poll, and it's asking what is most important to me is option A, making sure there is a written plan to handle, B, avoiding living probate and or death probate, C, making sure nursing home cost doesn't use up all of my assets, D, making sure my estate stays with my children if they get divorced, E, protecting my estate from death tax, F, protecting my children's inheritance if my spouse gets remarried after my death, and G, protecting my child with special needs after I die. All right, I see some of you voted now. There is a wide variety of answers, Nydia. You will see that in the results. So I'm gonna give it a few more seconds and we're gonna end the poll. Can you show the results?
Yes, I can. All right, avoiding living probate and or death probate is the absolute winner. Each of the answers had a response there, but the clear winner is definitely avoiding living or death probate. And so the answer, the good news is that you can absolutely do that. Any of these, if any of these were your concern, you can absolutely do that, and you are definitely in the right place and at the right time, because I've got to tell you that most of the people that come to our office after the death or incapacity of a loved one have virtually nothing in place. So this is the time to make that happen. So what's the next step? Well, the next step is going to be up to you. The next step is obviously to schedule a consultation, and the consultation fee is $450. But like I said at the beginning, my job here tonight, my real job here tonight, is to motivate you into planning. And so to do that, what we do is we give an education credit to everyone who completes this webinar. And so the education credit has a value of $325. So the consultation fee after the application of the education credit is $125. So the education credit and coming through this webinar is really valuable, because now you know more and you can do the best planning, plus you do get a credit for it. When you do the consultation with us. The consultation typically takes 60 minutes. If we do the planning right then and there, and we make good use of our time, it could take up to 90 minutes. I'm going to be in a quiet place, so I ask that you do the same. We like for all decision makers to be present. So if you're married, both spouses should be at the meeting. Uh, and if you're planning for your parents or something like that, then your parents need to be at the meeting. The meeting basically has three parts. I ask questions, you ask questions. I like to ask questions first because then I'm going to have the information to be able to answer your questions. We also provide you with a questionnaire, and that questionnaire is really helpful to prepare you and us for the consultation, and it makes the consultation really productive for us. So that's part of what's included in the question in the consultation, and you decide. And if you decide to plan, we design the plan right then and there. And if you don't decide that you do not want to plan, that's fine too. Now, all of our communications are subject to attorney client privilege, which means that they're confidential. So I mentioned that because estate planning sometimes has some touchy subjects, and I want you to feel comfortable sharing the dirty secrets, the dirty laundry of your family with me, because that's precisely why we need to do planning. In cases where there's lots of dirty laundry, then lots of planning needs to be done. So it helps me to understand the dynamics of your family when we plan. When you decide to go forward with the planning, 80% of the fees are due at the consultation and the balance is due at the signing ceremony, which, as I mentioned, is 2 to 3 weeks later. And we can do the consultations virtual or in person. We prefer to do them in person. So, one last story before we close, and this is a story, it's not fictional, it's a true story of one of my clients. Happened about 14 years ago. Elderly couple came to my office. They had a substantial amount of assets, very much like Fred and Wilma. They had 5 children. They did not want to plan after meeting with me because they wanted for their responsible son to chime in on their decision making. About 8 years after we met, I get a call from the responsible son, and he tells me he was asking me, had they planned? He had found my materials among their paperwork, and he had asked me, had they planned, hoping that they had planned. And I informed him that they had not. He told me that his mom had just passed away a week ago, and that his mom had become the main caregiver of his dad, who was incapacitated. So now they had to face death probate for the mom, guardianship for the dad, and it took almost 3 years of guardianship when the dad passed away, only to face death probate then. So I would say think about what you're leaving left undone. How you plan for the end is really critical in how your family is going to remember you, and and that'll have a lasting impact on your legacy. So with this, I quote my one of my all-time favorites, Pablo Picasso: "Only put off until tomorrow what you are willing to die having left undone." And we have other learning opportunities. Check out our website to learn more about those. And now, as I promised, questions and answers. And I just want to, before we go into that, I just want to thank you. You guys are troopers. You stayed till the end. So I'm going to stop sharing and let's go to the question and answer. Do we have any questions?
Yes, Nydia, we have a few questions here and more coming in the chat. First question: what if I have a power of attorney? Will I still be able to manage the affairs for my spouse?
Yes, a power of attorney basically allows you to manage the affairs. The principal is the person that issues the power of attorney. The agent is the person that's given the power, and you can manage the affairs. But I've got to tell you that institutions are very reticent about honoring powers of attorney, so they make it really difficult. Some institutions require a power of attorney that is within a certain length of time, typically 30 days or a year or something like that. So powers of attorneys are very effective tools to manage the affairs of a third person. But, many institutions do hesitate to do that. So in the estate planning world, we frequently recommend the trust, so because it's much easier to manage as successor trustee.
Thank you, Nidia. We have another question here coming in the Q&A box. Do you do living estate deeds?
Living estate deeds, that might be a life estate deed that you're referring to. And yes, we do those. There are various forms. So, for tax reasons, both state and federal tax reasons, you're going to want to have the correct type of life estate deed. A life estate deed, for those that do not know, is during my life, so and so has title, and it's typically from me to me during my life, and upon death to so and so as remainderman.
Excellent, Nita. I have some other participants here saying that they wanted to schedule the consultation right away, but they have to leave, unfortunately, the webinar now. Do not worry. We're going to be reaching out to each and every of you tomorrow. One of the team members is going to reach out to you. So for those of you writing in the chat, I'm writing down your names, but we're going to reach out to every single one of you. So don't worry about it. And you will definitely be able to have your consultation and, of course, use your credit. All right. And they're also saying that thank you so much. This is very valuable information. All
Thank
right.
you.
Another question. I am married, but my spouse and I have children from other relationships. I want to make sure that my children get their inheritance in the event I pass away first and my spouse remarries. Can I transfer my assets to my children now?
No. Okay, so for mixed families, estate planning is very important because you can absolutely create a trust where you transfer your assets to your children when you pass away. So, a lot of things to consider. Florida has what's known as the elective share, so you cannot disinherit your spouse. So we would have to take that into account. And you definitely want to make sure that you leave the inheritance for your children. So you want to make sure you set that apart. So planning for mixed families is critically important, more important than traditional families, because in traditional families is pretty much what the statutes have been created to do. So mixed families definitely need added planning.
Excellent. I have one more question here coming in the chat. My mom did not have a will. She passed away in 2017. It's my sister and I. We have been renting the property, have been able to make the payments, but now with interest rates so low, we want to refinance the property. When we called the bank, they told us we needed to get permission from the court. How can we do this?
Okay, so that is a probate question. So anytime that you're dealing with affairs of somebody that has passed away, in this case, your mom passed away and the title to the property was hers. So you're looking at probate, and you would have to go to probate, and we can help you with probate. The education credit that we're offering is not for probate consultations, but we would love to be able to help you with that.
Okay, excellent. I have another participant in the chat saying, I want to do a Florida Lady Bird deed. I only want my daughter to get my home when I pass. What do you think of this?
So yeah, you could do a ladybird deed for your daughter to get the home when you pass. That should be a ladybird deed is a life estate deed. And so that should be no issue. My concern is your daughter an adult? If your daughter is an adult, that's great. That can happen because in Florida, minors cannot own property. So if your daughter is a minor, that would be subject to guardianship. So as long as your daughter is an adult, that's great. Hopefully, your daughter doesn't have creditor issues, because you can protect inheritance to your children when they have creditor issues. And then the last thing that I would be concerned for your daughter having outright distributions, because that would be an outright distribution, would be if there's any possibility of divorce, and that inheritance could be commingled with her marital assets. So yes, you can do a ladybird deed from you to you and remainderment to your daughter.
Excellent, Nidia. Thank you for answering that. Also, another participant says, if the title is under one of the spouse, is the survivor entitled to the house?
Not necessarily, no. But again, I remind you of Florida's elective share, where you cannot disinherit the spouse. So homestead property is really tricky. Even if the spouse is not on title, homestead cannot be devised away from the spouse. The minimum that the spouse would get is a life estate, meaning that the wife has the right to possession during the surviving spouse, I'm sorry, has the right to possession during the surviving spouse's lifetime.
Thank you. Another question here. Someone is saying that he's a resident of Puerto Rico, but he owns a house in Florida. The value of the house is 500,000. Will estate tax apply?
And sadly, yes. And this is a really dicey one because Puerto Ricans are U.S. citizens, but they're not U.S. residents. And during the presentation, I was really careful to keep saying U.S. persons. So I didn't say U.S. residents, U.S. citizens, U.S. persons. That's a separate definition. And so it's the same thing as non-resident aliens or what have you. So any property that is situs located in the United States is going to be subject to estate tax with an exemption of only $60,000. So if the property was worth $500,000 minus $60,000, $440,000 would be subject to estate tax at the rate of 40%. So that's a whopping chunk of that asset that's going to be dissipated to estate taxes.
Thank you. And we're going to close with two more follow-up questions that we have here in the chat. One of them is the person following up saying that the house was not homestead, referring to the question regarding the person entitled to the house. So
Okay,
it was not a homestead.
so if it's not homestead, then it can be devised, and then my only concern remains the elective share. In Florida, the elective share means that you cannot disinherit your spouse. Your spouse must be entitled to at least 30% of your gross estate. So, depending on the composition of your estate, um, the right answer in this case is it depends.
All right, thank you. And also the client from the Ladybird Deed was following up. She's asking for costs and also if the Ladybird Deed, if we do this service in our firm, and if she does the Ladybird Deed, does the homestead increase?
It should not. It should not. So that's one of the beauties of the Ladybird deed. And then in terms of cost, if it's just a Ladybird deed, it's typically going to be $850 plus the recording fee.
All right. Excellent. And one last question. I know we're already over time, but we wanted to, please everyone asking. Another question saying, can a property be in a deed to an individual and a trust agreement?
Oh, I
I,
don't understand that
I
question.
think that the person wants to say if the property can be, I guess, put in a trust or in an individual as
You
an
can
agreement.
put you can put the property in the trust and then in the trust say a specific gift. I want so and so to have this property. But think about this. You could put the property in the trust, you fund transfer title of the property to the trust, which I like, and then you can say, I want so and so to get the property. But what if so and so passes away? Then so and so gets it. And then you can also say, I want so and so to get the property in trust so that now that property remains protected from all the protections that we've talked about. So I believe that your question was whether real property could be transferred to a trust, and the answer is it can. And then that real property can be devised from the trust either outright or in subtrust to the person that you want to leave as beneficiary.
Thank you, Nidia. Those were all the questions that we had. And that's it.
Okay, well, folks, I just want to thank you. You guys are troopers. You stuck it out. You all stayed till the very end. So I just really thank you for that. I look forward to speaking with each of you in the coming weeks. And I look forward to serving you. Thanks so much for watching. Thanks so much for learning about estate planning. I know that you will be better able to protect what matters most to you. Have a good night.
Thank you. Have a good night.